Good evening, everyone. Thank you very much for joining our Fireside Chat today. My name is Lydia Tan. I'm a committee member at HK45 and an accounting and quantum expert at BRG. For those who are new to HK45, we are a Hong Kong IAC young practitioner group. We regularly organize seminars, career events, and social events. Our aims are to provide a platform for members to learn from each other and leading professionals. We welcome members from all age, and so we hope more of you will be signing up on our mailing list and follow us on LinkedIn. So after 3 years, we are delighted to bring back our first in-person fireside chat to hear from our leading practitioners in the arbitration practice, their life experience, and also their career journey. Today, we are very honored to have Sir Bernard Riggs with us. Sir Bernard was appointed to the High Court of England and Wales in 1993. He sat predominantly in the commercial court, of which he was judge in charge from 1998 to 1999. He introduced the commercial court, the Wolf reforms to civil procedure law, and redrafted the commercial court's guide and practice directions. In 2000, Sir Bernard was appointed to the Court of Appeal of England and Wales, where he sat for 13 years and delivered a wide range of judgments on arbitration, aviation, shipping, oil and gas disputes. In 2013, he was appointed to the Cayman Islands Court of Appeal, where he sat for a further 10 years before retiring in December 2022. He remains an international judge of the Singapore International Commercial Court and a professor of international commercial law at Queen Mary, University of London, but now spends much of his time sitting as an arbitrator, mediator, and expert witness. I'm also pleased to introduce the host of today's interview, Ben Burry. Ben is one of the committee members of HK45 and a partner at HFW in Hong Kong. Ben is a specialist construction lawyer, advising clients in relation to disputes arising out of complex and high-value construction projects. Before I pass to Ben, just a few things on the rundown. We will have Q&A section after the interview, so please share your questions. And we have also arranged cocktail sections afterwards, which is sponsored by BRG. So please feel free to stay and enjoy the networking drinks. And on that note, I will hand over to Ben.
Oh, I see, right. Well, I think most people can hear me anyway, even at the back. Feel free to come closer to the front if you want. Welcome, everyone, to a very special fireside chat for a couple of reasons. One is what Lydia said about it being the first in-person fireside chat we've had since COVID, and it's fantastic to be here today and actually be in front of everyone. And of course, because we're meeting Sir Bernard Riggs, who, for all the reasons Lydia mentioned and we'll get into today, we are really honoured to have you here today, sir. Thank you so much. Sir Bernard just confided in me that he arrived in Hong Kong at 5:30 yesterday morning. He's been at hearings all day yesterday and all day tomorrow. So if he suddenly slumps forward in his chair and falls asleep, I think he'll be forgiven. But thank you for taking up your valuable time to meet with us today.
I may not be able to answer your question.
So we'll start, Sir Bernard, we'll start with some easy ones. So we usually in these talks go right back to the beginning because it's a nice way of us getting to know you a little bit more. And so who are your influences growing up?
My parents, my elder sister, not much older, my first primary school teacher in kindergarten, whom I fell in love with and proposed marriage to at the age of 4. Later on at my secondary school, where I was a classicist, very well taught in Latin and Greek, and my Latin master, a very dour Scot, but with very high standards, and my Greek master, a rather relaxed Englishman who was both an international bridge player and an international croquet player.
Right.
They were big influences on my scholarly upbringing, really. So let's say that.
And you went to Oxford University and you studied law, did you? Or did you study classics?
No, I studied classics.
You studied classics.
I did, and then law, and then law. So 4 years of classics. And then I went back to being an undergraduate again, very leisurely, and did 2 years of law. And then went to Harvard Law School to do a master's. So 7 years in all. But my first love is classics.
Well, your love of learning, as you say, didn't just start and end with at Oxford. As you say, you went on to Harvard, and you are now Professor of International Commercial Law at the Centre of Commercial Law Studies at Queen Mary University in London. So why is, clearly education is very important to you. What is it that motivates you in that? What do you see education as being so important?
Oh, well, education isn't everything, because there are other things and other compensations, but it's jolly important. And I mean, you either like reading or you don't. If you like reading, then the academic path is much easier. I mean, I had friends who didn't like reading. I've got we're quite an academic family. One of my 5 children is not academic, but the other 4 are. I mean, I think it's just the way you are. But learning is a wonderful thing, and I think I had the great advantage of having a mother who left school at the age of 14, which is what you were allowed to do in her time. And she was the one in my family who was most determined that my sister and I get an education. My father, who went to university, was much more relaxed about it.
So you got this love of learning from your mother.
Yes, yes.
And you pass it on to your kids, obviously.
As much as I can, yes.
So as a barrister, you practiced in 3 Essex courts, chambers, which is now called 20 Essex, where you eventually returned, of course, after you left the bench. As a junior, you were led by some of London's leading silks at the time, many who went on to sit on as judges themselves. Which individuals do you remember in particular from your time as a young lawyer in London?
Oh, well, many. My pupil master, who led me in due course, Kenneth Rokerson. He never wanted to be a judge. He became a very famous international arbitrator. And he was a great influence and a great pleasure to work with. A very humorous man. Robert Gough, the future Lord Gough, led me once, and that was absolutely wonderful. And if the case began on a Monday, which it did in this case, he would invite you to his home over the weekend, and you would work together on the case, and his children would come in and play you the cello or whatever it is they wanted their father's approval for. And Mrs. Gough, as she then was, would cook you some lunch. And then Robert would send you away to chambers to do some research, and you would go back at about 10 o'clock at night to give him the results of your research. And then he would send you home at about midnight, while he got down at midnight to write his opening argument. And then you would come along the next morning and you'd hear his opening argument, absolutely brilliant, all done overnight. And this was a great learning experience, really. Yeah, absolutely wonderful. I was once led by John Hobhouse, the future Lord Hobhouse. Also a wonderful experience, really, but not nearly as much fun.
You specialised in international commercial arbitration at an early time. And that was, of course, also a time when arbitration was not nearly as well known as a career path as it is now. what was it that interested you in arbitration over the more, I suppose, more traditional practices of the time?
Well, I mean, we were a set of commercial chambers, and although arbitration was not what it is today, it was perfectly strong, particularly in shipping, which was a particular specialty of my chambers. And I remember one of the first cases that I went to as a pupil, right, before I was taken on in chambers, was a shipping arbitration at the Lloyd's Exchange. And I remember Christopher Staunton, a silk in my chambers, the future Lord Justice Staunton, at that arbitration, dealing with the pleadings of the opposite party, which he described as not worth the paper they were written on. And he picked up the points of defense. I think he was opening the case for the claimant. He picked up the points of defense and he just ripped up a copy of the pleadings in front of everyone and threw them on the floor. I thought that was a very good introduction to arbitration indeed. So it goes back a long way.
You would have done it yourself.
Well, it was another lesson. It was another lesson, wasn't it? Arbitration has steadily grown more and more and more popular between commercial parties. We can talk about that in due course, whether that is an entirely good thing or not. But at any rate, so far as my being an arbitrator now, well, I was introduced to it back then. And when you become time expired as a judge, arbitration seems to be the natural thing to do.
In 1993, you were appointed to the High Court and sat predominantly in the commercial court, as we were hearing from Lydia, of which you were judge in charge for a period. In 2000, you were appointed to the Court of Appeal, and you retired from the Court of Appeal in 2013, but you still sit as a judge, of course, in the Singapore International Commercial Court. In your time as a judge, you presided over a truly incredible number of cases, many of which concern arbitration. In the process of trying to prepare this talk, I put in your name into the search engines in the English court database, and I was totally overwhelmed, even trying to whittle it down to just the number of judgments that Sir Bernard's judgments have been referred to in the Hong Kong court is overwhelming. It's a truly incredible legacy that you've left. What are, it's an impossible question almost, but what are some of your most memorable, I suppose, cases, and why do they stand out for you?
I think the most memorable case I did at the bar, and then we'll come to the most memorable case I did on the bench. This memorable case I did at the bar was a wonderful dispute between Chile and Cuba, essentially between Chile and Cuba, although it concerned the sale of sugar by then, and that's still now communist Cuba, to then communist, but no longer communist Chile. And when General Pinochet overthrew Allende, whenever it was, in 1970 or
I'd love to interject here with my knowledge of it, but I'm afraid not.
there were two sugar ships, one from Cuba in Chile. One was in the course of unloading, and the other one was just over the horizon coming towards Chile. And the balloon went up, the revolution took place, and Cuba messaged the two captains of the ships to just get out of there as fast as they possibly could. And the ship that was unloading in Valparaiso Harbor just broke anchor and steamed away, pursued by a destroyer and helicopter. the destroyer put some shells through its bows, and it still didn't stop. And the destroyer had to decide whether it was going to sink the ship with the sugar on board, which Chile had already paid for, or whether it was going to let it go, and it let it go. And the other ship never arrived. And that led to a wonderful dispute over the loss of those two cargoes, which Chile had paid for. Arbitration before the Sugar Association in London. And that led to an arbitration award, which went up to the Court of Appeal, and it led to the arrest of a Cuban ship, which went to the House of Lords on the great subject of sovereign immunity in a case called Primo Congreso del Partido, which changed the law of sovereign immunity in the UK on a subject which I'd learnt about at Harvard Law School. Wonderful. So that was a great case. And I got it as a very young junior, very early on in my career, in August, when everyone else was away. The brief was supposed to come into my head of chambers, Tony Lloyd, the future Lord Lloyd of Berwick. And he wasn't available, and so they said, well, what about Christopher Staunton? And he wasn't available. And they said, how about Kenneth Robertson? He wasn't available. And then the clerk said, well, the only person in Chambers really is the latest recruit to Chambers. He's very, very young, but he's very, very good, and he's the only person here. And so that's how I got onto that case. And I continued happily in it until I was in Silk. And then we won in the House of Lords on the subject of sovereign immunity. So that was great fun. And on the bench...
the moral of that story is stay in Chambers in August.
Yes, oh, it is. Yes, yes, absolutely. I don't know what the equivalent of August is in Hong Kong, but stay in Chambers when everyone else...
I think it's August, yeah.
When everyone else is on holiday. And on the bench, there were some wonderful cases arising out of the invasion of Kuwait by Iran. And I think the best of them concerned a Belgium-Dutch dredging fleet, which was dredging the Shatt al-Arab when war broke out. When the invasion took place and war was coming down the line in Iraq. And that was a great case, full of points of marine insurance, illegality, conflict of laws, United Nations sanctions. That's absolutely wonderful case called Royal Boscalis and whoever the insurers were. It was an insurance claim. And I was quite a young judge, and it was a very difficult case, and I wrote a judgment on it, which is reported in a very slightly out of the way report, but it's got most of the modern law of marine insurance on it. It's also got the modern law on illegality about 20 years before the Supreme Court changed the law on illegality in Patel and Mirza. But anyway, the Court of Appeal said I was wrong on illegality and other points as well. I didn't think much of the Court of Appeal decision. In the meantime, I wrote another long judgment on the quantum of the insurance recovery. My first judgment was on liability. My second judgment was on quantum. And the Court of Appeal said I was wrong on liability. There was a petition to go to the House of Lords, which was granted. And no sooner was it granted than the case settled for the precise amount which I, to the last cent or penny, that I had awarded in my judgment on quantum. So I considered that to be a bit of a victory.
Success.
So that was a good case. And then I did a wonderful case on human rights. I'm not commercial, not arbitration, but I should mention it. That was about deaths in Iraq. Iraq has figured a lot in my career, about deaths in Iraq at the hands of British troops. And a human rights claim was brought against the Ministry of Defence in Britain by the family of the victims. And the question was whether the Human Rights Convention and the British Human Rights Act applied outside Britain, whether it applied in Iraq. A very interesting jurisdictional question. And I said that it did, so far as one death in a British prison in Iraq was concerned, because that was quasi-territorial, albeit outside Iraq, British prison. But I said it didn't apply to the deaths in the highways and the byways of Iraq. And the Court of Appeal disagreed with me and said it applied to all the deaths. And the House of Lords agreed with me and said it only applied to the death in British prison. And then it was taken to the Strasbourg Court from the House of Lords, who said that it applied to all the deaths. And they said, departing from their earlier decision, that it applied to, the convention applied outside Britain or Europe. There we are. That was a great case.
So that was a partial success, that one.
Well, it was an ultimate failure, but it was very, very interesting. It was extremely well argued by Professor Christopher Greenwood, the future British judge at the International Court in The Hague, representing the British government, and Rabinder Singh, a future judge of the Court of Appeal in Britain. Both wonderful advocates.
I mean, I want to ask you a few questions now about arbitration, because of course we're here in the Hong Kong International Arbitration Centre, and in light of some of the decisions you've made, but also comments you've also made elsewhere. And I want to start by talking about the issue of the proper law of the arbitration agreement. In March this year, the Law Commission of England and Wales published a consultation paper on its review of the Arbitration Act in England and Wales, 1996. And it endorsed a proposal for a new statutory rule that the law of the arbitration agreement is the law of the seat, unless the parties expressly agree otherwise in the arbitration agreement itself. And this was in a response to a letter to the Laws Commission in December 2022, which you signed. And the letter warned the Law Commission of the dangers of a decision, which will be known to many of you in this room, of the Supreme Court of the United Kingdom in HK and Chubb, which was delivered in 2020, regarding the proper law of an arbitration agreement. Now, interestingly, in the same month that the Law Commission gave its consultation paper, March this year, HK and Chubb was applied by the Court of First Instance for the first time here in Hong Kong in the case of China Railway and Chungking Holdings. And it therefore represents the current state of the law in this jurisdiction. So I thought that it was a very valid question to ask you what your concerns are about the Supreme Court's analysis in HK and Chubb regarding the proper law of the arbitration agreement. And perhaps you could start by explaining to the audience what their analysis was, and then go on to say why you were concerned about the dangers of it, because of course this is something I think all practitioners here in Hong Kong must be acutely aware of now.
Well, you'll have to forgive me and help me if I get this wrong, but I think that basically what Enker and Chubb decided was that if there was no express agreement of the proper law of the arbitration agreement, it should take its proper law by implication, essentially, from the choice of substantive law.
Yeah, that's correct.
And that represents the law really going back to the 19th century, when really the common case that came before the British courts was a contract for English proper law. And the courts were quite happy to say that that meant that the arbitration agreement had the same law.
Yeah. Substantive law being the law of the contract, which I'm sure everyone is familiar with, just in case there is.
But nowadays, it is very familiar to find that there are lots of arbitrations, agreements for London arbitration, which don't necessarily say what the proper law of the arbitration agreement is, but with proper or substantive laws of the underlying contract being some foreign non-English law. And that's quite common. So if you follow Enker and Chubb's analysis, you will find that the arbitration agreement will be given some foreign law, which might be any law at all. It might be French law, might be Turkish law, might be Russian law, Chinese law, might be almost anything. And that would mean that there would be a great danger that there would be a clash between the proper law of the arbitration agreement and the law of the seat of the arbitration, and therefore Arbitration Act 1996. And you wouldn't quite know where you would be going. And we were rather concerned about that. My memory is, you may correct me, that when the Law Commission began its consultation, its proposals and consultation for a reworking of the 1996 Arbitration Act, now over a quarter of a century old, they had it in mind to introduce a statutory adoption of the law of Enker and Chubb. And that really set the alarm bells ringing, because now you would have the Supreme Court decision enshrined in statute. And so a number of us, I wasn't there right at the beginning, but it was Lord Hoffman and Lord Mance, as I recall, and perhaps someone else as well, who started saying that this would be a bad idea. And I was roped in, and we wrote to the Law Commission in their original consultation to say bad idea, and we've persuaded them to change their minds. So they're now consulting on a revision to say that there should be a statutory disavowal of Enker and Chubb, and that's the present position.
Yeah.
And the concern is that you will really set London arbitration at 6s and 7s if you either make it rather difficult to have a proper law other than English law, because that will involve arbitration agreement governed by some foreign law, or you will really start undermining English arbitration by reference to a foreign substantive law brought into effect as the law of the arbitration agreement, which will lead you into arbitration doctrine. You may not know what. Perhaps no great harm if the foreign arbitral law would have an unsatral law, but of course, as we know, English law is not down the line model law stuff, and it would clash with the Arbitration Act, and we wouldn't know where you were. So we thought that was a bad idea, and we hope that our proposals through the revised Law Commission consultation will bear fruit. But that's the point.
And and if they do bear fruit, the relevant point to the people, particularly in this room, is that then the statutory position in England and Wales will be different to the position in Hong Kong. Whereas,
but I suspect the position in Hong Kong would change.
Would change.
I mean, I suspect because the statute would show that for very good reasons, the decision of the Supreme Court, which I think was only expressed as being the prima facie position, I think, was doubtful, and it may well be that a higher court, because at the moment the case you've cited is only a trial court decision, isn't it?
Yes, it's the court of first instance here.
Court of first instance.
Yeah.
And a higher court may well decide, as it were, to follow statute rather than the Supreme Court. But who knows?
And the Hong Kong arbitration ordinance is in many respects quite closely aligned with the Arbitration Act 96, although there are some differences.
And the reason for the statutory change will all have been set out in the consultation papers and so forth. One of you good advocates will be able to argue the position in the Court of Appeal of Hong Kong very well.
Watch this space. Watch this space. Injunctions I want to talk about briefly. One of the most well-known cases in which you appeared as counsel, this is before you went to the bench, is the case of Mareva, Compagnia Navira, and International Bulk Carriers in 1975, which is the origin of the modern freezing order, also known as the Mareva injunction, after the name of the case. And freezing orders are now commonplace in the context of arbitration, due partly to the rise of injunctions in aid of arbitration, and partly to the ability to seek such relief directly from an emergency arbitrator. You could, of course, get it from an arbitrator before, but the emergency arbitrator provision has, of course, increased prevalence. Here in Hong Kong, His Honour Judge Stone in the Court of Appeal, in the case of, I'm going to pronounce this wrong, Dulama Shipping, remarked that the freezing order or Mareva injunction has become so much part of the common law procedural machinery since 1975 is so frequently resorted to that there's a danger that judges and arbitrators are taking the relief for granted. And he warned against superficial judicial familiarity with the form of the application may obscure the vital necessity of careful and critically scrutinizing the material placed before the court or arbitration. Do you think there is a risk that over familiarity with the famous freezing order might lead courts and arbitrators to grant it when the material may not demand it?
Well, I suppose there's always that possibility. The idea is that you can find material in the case to suggest on the quite low test of interim injunctions, right? Balance of convenience test, that the ease with which nowadays, and it's only grown easier since 1975 when the Mareva came into existence, so easy to transfer monies and so on and so forth, that in effect a defendant can make itself judgment proof by the transfer of its assets out of the jurisdiction. And that's the vice which the Mareva injunction is trying to deal with. It's a great instrument for justice in the world. Lord Denning, in one of his books, described it as the most important case of law reform in his lifetime. So although there is a danger, of course, of its misuse, and for a while, its novelty was controversial, and there has been a strand of opinion which on the whole over the years has diminished, that because its effect is so powerful that one should be particularly cautious about using it at what is, after all, only an interim stage before liability is established. But on the whole, the ultimate justice of the injunction has been seen to work in its favor. And as long as one has in mind that you need proper evidence of a risk that the jurisdiction will be abused by a defendant seeking to make itself judgment proof in the jurisdiction, as long as you require some proper argument to that effect, I think that that it's fine. But there you are. The controversy has always existed. It existed in 1975 when Mr. Justice Donaldson, then Commercial Court judge, had set his mind adamantly against the injunction until Lord Denning put him right in the Court of Appeal, in my case. I'm inclined to think that those who see in it the opportunity for the avoidance of injustice have somewhat the better of the argument than those who say that it is a grave, it is in grave risk of doing injustice. And we've now had half a century of testing that pragmatically. And
times you've granted it yourself, sir.
Yeah, well, yes. And early on in my career as a judge, I granted an anti-suit injunction in what was it called, the Angelic Grace.
Yeah, yeah.
Very controversial in its day.
Yeah.
But now sanctioned by the House of Lords and the Supreme Court, and perfectly familiar in the common law world, very unpopular in the European Union world, but popular in the common law world and well established.
Yeah.
Yeah.
Yeah. Yeah. Well, that is, yeah, it's regularly cited, of course, in Hong Kong as well. Arbitrator's jurisdiction. Although an arbitrator has the power to consider his or her own jurisdiction, the competens principle, the court may also consider the same issue. In the case of Azov Shipping and Baltic Shipping, which is from 1999, you said that where there was a substantial issue of fact as to whether a party had entered into an arbitration agreement, which of course is a jurisdictional point, then even if there had been a full hearing before an arbitrator on that issue of jurisdiction, the court may reconsider it for the purpose of determining a challenge to the tribunal's ruling on jurisdiction. And this decision has been consistently applied in England in quite a well-known case called Peterson Farms in 2004, and in Hong Kong in ESCO and BCO from 2014. You actually repeated this view when sitting as a judge in the Cayman Court of Appeal. And I'm just going to read briefly what Sir Bernard said. The principle of competens is merely the doctrine which says that it is thought in general to be better and more efficient if the arbitrator takes the first or initial look at the issue of jurisdiction before it comes to court for its definitive judgment. Now, I think it's fair to say that that's slightly controversial in some positions for arbitrators. And as a judge and arbitrator yourself, do you recognize the tension in permitting both an arbitrator and the court to consider the same issue of the arbitrator's jurisdiction? And if so, do you think we've got the balance right?
Under the Azov principle.
Yeah.
Well, you can cut it as a matter of pragmatism wherever you think it right to do so. But as a matter of principle, if there is a dispute as to the arbitrator's jurisdiction, it is impossible as a matter of principle to say that the arbitrators should have the last or even an influential view about whether they have jurisdiction or not, because that is bootstraps, right? I mean, there is an issue about whether the parties have agreed arbitration in this case, or arbitration at all. That's the issue. How can you leave it to the arbitrators, who perhaps shouldn't be there at all, to decide that issue, or even to have a really influential role in that issue? That's the principle, right? Now, pragmatism is very interesting as well as principle. On my way to Hong Kong, I stopped off in Tel Aviv to give a lecture on principle and pragmatism to a university there in Tel Aviv. So, as a matter of pragmatism, where you start an arbitration in which the jurisdiction of the arbitrators is disputed, what are you going to do about it? Are you going to say an issue of jurisdiction has arisen, go straight to the court, right? Or are you going to say, give the arbitrators the first bite on it, on the pragmatic basis that they're already constituted, their decision may solve it for the parties. It may be the sort of problem which can only be really discussed together with the merits of the case. So there they are. Give them the first bite, not the definitive bite, because otherwise it's bootstraps, but give them the first bite. That's the theory of competence. The theory of competence is not the theory that they should have the last word. This is the theory that they should have the first word. All right, that's a pragmatic decision. They have competence to decide their own competence, but not definitively. That's the doctrine of competence. Now, that still leaves a party who has lost the jurisdictional issue before the arbitrators the chance to go to the court for a court decision. So what are you going to do? Are you going to say that the arbitrators should have the last word? But if you say that, that is to say that parties who may not have agreed the jurisdiction of the arbitrators should be bound by the decision of the arbitrators. Well, that's not very satisfactory. I mean, you can cite it if you want, but it's not a happy decision. So, should you say, what is the law at the moment? Not just Peterson Farm, which I think is a decision at first instance, but Dalla, which is a decision of the Supreme Court, upholding Azov. So should you say, well, not only is the judgment of the arbitrators not definitive, but you can start right again from the beginning and have new evidence before the court when you get to the court. Well, there you have another pragmatic decision to make. In principle, you should be able to do so because you simply may not have agreed to arbitrate. So why shouldn't you be able to start again with new evidence before the court? Pragmatically, you might say, oh, well, that's really rather wasteful, and you should impose upon the parties, in the light of competence and competence, which is a almost universally accepted route to give the arbitrators the first decision. You could impose upon the parties, as a matter of pragmatism, the warning that if they want to, if they need to have evidence in order to discuss the point of jurisdiction, as they may well need to do so, was a contract ever entered into? Is the claimant a party to the contract? Is the respondent a party to the contract? This may well require evidence. It may require evidence of foreign law, because the contract was made abroad, because the contract is a putative foreign proper law, and you may need expert evidence as to foreign law and so forth. So you could say, well, be warned, because any evidence that you need to resolve this question as a matter of the competence stage before the arbitrator is your last chance. Don't think you're going to get another chance to present different evidence before the court if you need to go before the court. And you could have such a rule. Such a rule would be a matter of pragmatism, not a matter of principle. So as of is a decision as a matter of principle, right? Which is that it's bootstraps to say that you're stuck with the way it was argued before the arbitrators. But you could have a rule, a pragmatic rule, which says that you can't start again with new evidence. But why shouldn't you be? And then the question might arise: well, can you raise new arguments? Perhaps it should be the last chance for you to raise an argument, and that's going still further. You might say, well, you can't have new evidence, but you can have new arguments, because a matter of law, there's no reason why, as a matter of law, you can't have a new matter of law before the court, which you haven't had before the arbitrators. So you can cut it and slice it as a matter of pragmatism. But I think as a matter of principle, the decision in Azov, upheld in Dalla as a matter of Supreme Court judgment, is right in principle. Now, the Law Commission proposed in their first consultation to go back on the decision in Dalla and statutorily to enact a view that you couldn't have a second bite, okay? And I think that in the same letter which Lords Hoffman and Mance and Sir Bernard wrote to the Law Commission, we said that that was wrong in principle. And I'm not quite sure what the Law Commission is now saying second time round. But there you are. There's a decision of principle to be made there, and there's a decision of pragmatism to be made there. But my belief is that although one or two countries may have taken the pragmatic route, I think most countries allow the review of jurisdiction by the courts to be a de novo review. Now, the court is always entitled to say, they will have the award in front of them, the court is always entitled to say, well, we're impressed by the reasoning of the arbitrators. But they're not bound to do so. And I don't think they should be bound to do so, because otherwise you would be unfair to the party who says, but I never agreed to arbitration, and who would be stuck with the decision of arbitrators.
Well, I suppose, yes, I suppose that's the distinction between, you know, a situation where the arbitration decision would be brought, arbitration award would be binding, because that's in a situation where the parties have consented to the award being binding by entering into an arbitration agreement.
Well, they haven't.
If the issue is whether they have consented to an arbitration agreement, then it should be applied, a different lens should be viewed through a different
Not
lens.
only is it not binding, but it has no validity whatsoever. If you haven't agreed arbitration, the decision of the arbitrators has no validity at all. If you've got an issue about whether you've got an arbitration agreement or not, someone has to decide it. And it's a matter of pragmatism as to who decides it first and who decides it definitively. But to say that the decision of the arbitrators should be definitive can't be right.
I'm conscious of the fact that I want to give the audience a little bit of time to ask a question, so I'm going to move forward, but depending on how many questions we can go back to some of these points. I'm going to jump fast forward to precedent, which is a point you've talked about on a number of occasions. Of course, everyone in the room will be familiar with the fact that an arbitral award, no matter how significant the point at which it determines it may be, it's only effective as regards the parties to it and persons claiming through or under them. It doesn't bind third parties or the public at large, nor can it be invoked by them. In fact, in many instances, no one even sees it because, of course, it's confidential. Now, in 2015, you gave a presentation in Singapore remarking that the public interest is being damaged by the increased use of confidential arbitrations to resolve commercial disputes, because more and more decisions on areas of commercial law are becoming inaccessible to the public. And you proposed as a solution, well, you proposed a number of solutions actually, but the one I focused on in particular was a framework for the publication of past arbitral awards, albeit maybe in an anonymized sense, so that these can be considered in the context of future awards. And the ICC actually does publish some past awards where consent has been obtained. But I think it would be fair to say that as matters stand today, the arbitration community around the world seems somewhat reluctant to adopt this proposal, even though if you speak to individual practitioners, most of them agree that it is a sensible solution to a serious problem. So how do we get out of this rut, if you like, and see and move to a position where your suggestion becomes more acceptable, if you like, to the arbitration community?
I think this is a very serious issue. Over the decades of my practice, arbitration is now covering more and more and more of commercial disputes, and fewer commercial disputes are going to court adjudication. And that is a matter of public interest concern, because if the commercial law goes underground in confidential, unreported arbitration awards, then you are not refreshing the commercial law of your nation, whichever it may be. And so far as the law of England and Wales is concerned, our commercial law is thought to be a valuable thing, as reflected in the fact that so many people from all over the world agree in their contracts to have their disputes resolved by English law, either in the courts or in arbitration. Well, if your commercial law becomes old-fashioned because you haven't got enough public disputes going through the courts, that would be a bad thing. You would have an old-fashioned law. Well, an old-fashioned law is no good to man or mouse. It's a harm. It's harmful. So what's the solution? One solution is to allow appeals from arbitration awards, and that's the solution that we had in the old days when I became a barrister under the special case procedure. But the special case procedure became abused because it meant that almost every award could be got into the courts. And so that was not very satisfactory. So then we made it extremely difficult for awards to come into the court.
Which is where we are here.
Which is where we are. And on the whole, people think that that is more or less satisfactory. But if you are going to stop awards coming into the courts for the sake of finality of arbitration awards, then you have to do something about the confidentiality of arbitration awards. And if you did something about the confidentiality of arbitration awards, you would have the awards, they wouldn't have the precedential value of a judgment of the court, but they would be there, they would be in the public, and they could be cited to the courts for what they're worth, all right? Depends who the arbitrators are. You have really very distinguished arbitrators from all over the world, providing a great deal of important input into modern commercial law.
Be like citing a judgment from a foreign jurisdiction, I suppose. So
It would be like citing a judgment from a foreign jurisdiction, but these arbitrators would be very, very well known. And indeed, so far as the civil law is concerned, civil lawyers will tell you that it is the writings of jurists and professors rather than the judgments of the judges of civil law jurisdictions, which are the really valuable things. And where will you find the judgments of jurists and professors of the civil law? You'll find them in arbitration awards, because almost every distinguished civil law arbitrator is a professor, unlike common law arbitrators who are very often retired judges. So there you have some very distinguished people from both the common and civil law worlds writing awards, sometimes in a trio, as though they were a sort of court of appeal, right? Very, very valuable, you might think. I mean, they're worth what they're worth, but potentially very valuable. So why not have a look at them? Well, one reason, of course, is confidentiality and a reluctance to publish. On the other hand, arbitration awards are published. They are published in the bilateral investment dispute awards, ICSID awards. There are publications in America. The LMA may publish some, the ICC may publish some. And how important is confidentiality? Well, there's a dispute about that. There is some evidence that although it's important, it is not all that important. Of course, when it comes to it, people like to wash their dirty linen in private rather than in public. But I think the solution to this is not to make awards easily appealable, because that would really destroy the finality of arbitration, but to encourage the publication of awards. You can do it a year after the award is dated, which takes the sting out of publication. You can anonymize it. Then there's a dispute about who's going to go to the trouble of anonymizing it. Then there's the argument that you could take all the names out of the award, but people will know who the parties are. Yes, but the people who know who the parties are know who the parties are in any event, yeah. Because people in the trade know who's disputing about it. So I'm not much impressed by that argument. And I think that even if it imposes a bit of trouble upon the arbitrators, for which they can be paid, of course, if one moves to that situation, we should be publishing awards. One question is, well, you publish the legal part of the awards rather than the factual part of the awards. I'm not so certain about that, because it can be very difficult to understand the law without facts. Of course, many awards are essentially factual matters. They perhaps don't matter, but there's a lot of law in awards which I come across in my arbitral practice, and I think that it would enrich our commercial law if we knew much more about it. People speak very often about the lex mercatoria, but if you don't know what the awards are saying, you don't have a lex mercatoria. I'm all in favor of a lex mercatoria, an international commercial law, but without publishing awards, you'll never get it.
I wonder if arbitrators don't want to do it, because if you go to the HK45 Christmas drinks, you'll find two people who worked on the same arbitration on opposite sides, both saying that they won the case. And if it's confidential, then we'll never know who really did. But let me pause there for a moment. I'm interested in the thoughts in the room. Does anybody have any comments on that? The possibility of the suggestion that we have almost a default rule that the arbitrator, a year after giving his award, will anonymize it and publish it for the use of other arbitrations later on, unless I suppose there's some strong objection from one or both of the parties and it's justified. Would we all think that was a good idea? Some shaking heads. Why do you think it would be a bad idea?
Something very senior that is saying one of the major reasons a certain kind of industry player doesn't like arbitration is because it's confidential. They don't want the awards published. So I don't think it works. I think what might work, like a professor, is publishing chunks. And for example, Professor Berman gives his students chunks of judgment. There's a lot in awards that don't include like all the procedural history, which is also something extremely embarrassing. So maybe cut that out and focus on the guts of it. That might be more comfortable. But I think some institutions ask the publishers. I think that's the theme that's the publishers.
Yeah.
One and the other one. I've written, and I kind of summarize something that theory right. I agree with that. Maybe we need to look at PLs, and I know commercial court looked at it, but it's all gone quiet in commercial court. I think that was in 2015, so I don't know what's going on.
What do you think about that, Sir Bernard? The possibility of just sections of the award being.
Well, I've said you can cut it any way you want. Cut it any way you want. If you have to make a compromise, then the compromise which has just been suggested might be the one that will get it past the starting post. But I would dispute the argument which is often spoken of, which is that confidentiality is so important because there's been research on that. And although it is a factor, and if you like, an important factor, it isn't such an important factor. The research shows, the Queen Mary Whiten case studies on the matter, shows that it is not all that important. 50%, let's say 50%, not 100%, not 90, not 80, not 70, but 50% important. Well, of course, people would prefer to wash their dirty linen in private. Yeah. But if you don't want arbitration because it's not as confidential as you would like it to be, what are you going to do? Wash all your dirty linen in the courts? No, you're still going to arbitrate. So the question is, you know, would somewhat less confidentiality be the end of arbitration? No, of course it would, because the parties aren't going to go rushing into the courts when what they prefer is arbitration. They'll still arbitrate. But you know, I certainly don't think you should go back to the old days of having all the awards coming into the courts, because that's the end of confidentiality anyway. Of course, complete loss of confidentiality, and it means a complete loss of the finality of awards. One of the problems about this question of confidentiality is the competition between institutional arbitral institutions. Arbitral institutions think that if they give more confidentiality than their competitive arbitral institution, they will get more cases. And so some arbitral institutions, like the LCIA, I'm afraid to say, have the most stringent confidentiality rules. Other arbitral institutions have less stringent arbitration rules. So some institutions don't have confidentiality of awards. Some warn parties that the award may be published, or part of the award may be published. But the LCIA and others say even awards are absolutely confidential. Why do they do that? Because they think that they will attract more cases. Maybe you're right, but is it in the public interest? Yeah. Because what is in the private interest is not necessarily in the public interest.
No. And in the long run, it would be potentially a better situation for those arbitration parties to arbitration to have the benefit of some guidance from
modern commercial law. I mean, take insurance law, which when I was in the commercial court, all the cases were insurance cases. I mean, that was the flavor of the month. I think 70% of the cases I did in the commercial court were insurance cases. Now, insurance cases all have arbitration clauses, nearly all, and insurance law has gone underground. Is that a good thing? I mean, one reason why insurers like arbitration is that there may be an arbitral decision against them as insurers. They don't want that to be out there in the world, because all their insurers will say, look, you owe us money. And they don't want that. They want to impose upon their insurer the problem of reinventing the wheel. Mm-hmm. Well, is that a good thing?
Yes, questions from the floor for a bit. Go ahead, Pruderi.
Then result in an element of forum system. The students in the UK say that we believe in Wales say we now mandate anonymous publication later. We'll see a drift to Paris, to Hong Kong, to Singapore, which doesn't feed in yet, because it will still be confidential here, it will still end in press.
I agree that that's what would happen if you had a statutory change so as to require publication of awards. I agree. So the question is, how do you move to a situation where the public interest is preferred to this extent in favor of the private interest? And why not favor the public interest over the private interest? Yes? But you have to move cautiously. But you have to keep up the advocacy for it, because otherwise you're going to find 100 years down the line that your commercial law is 100 years out of date. And whose interest is that in? Not in the interest of commercial parties. So we've got to be moving about it. One thing is to encourage parties to think that confidentiality is not as important as all that. And there is a lot of evidence to suggest that it isn't as important as all that. I mean, you can say it's very, very important, but it's not 100% important. It's only 50% important on the evidence, okay? You can say, well, we won't publish an award until a year afterwards. And I don't know where you start. Perhaps you start by encouraging the arbitral institutions to agree that they're not going to have such stringent confidentiality rules. Or to agree to be more relaxed about it, or to encourage their participants to agree to the late publication of anonymized awards. But I think we should be thinking along these lines, all right? Because otherwise, we are going to find not only that we don't have the lex mercatoria, which we've spoken of for generations but have never achieved. But we're not going to have a good commercial law. That is a very, very serious situation.
Any other questions for Sir Bernard from the floor at this time? We've got, I think, 8 minutes left. If anyone. Yes, go ahead.
Great chambers were very involved, I think. But what I found very interesting is that you said the problem is the clash of the problem with the arbitration agreement and then the law of deceit. Whereas in the papers I've read, the big mischief they talk about is how much delay it causes. Because if you look at any, there's basically a 3-stage matrix test. If this, then this, then if that doesn't exist, then that, and finally that. And I see that, but it doesn't say in any of the papers, yeah, the problem is that clash. But is that the actual big problem, the clash of the law of deceit and the law of the arbitration?
Yes, I think it is. Yes.
Interesting. If they didn't phrase it that way.
Any more? And perhaps Shanks then, Frederick.
You mentioned it a couple of times about particular applicants having argued cases very persuasively for you. I wonder, in arbitration, we of course have the ability as solicitors to conduct our own advocacy. So if you have any tips or the sprung to mind, having very, very well there.
Well, I won't mention names, but I think the quality of advocacy in arbitration is very high in the arbitrations which I'm involved in, and the tribunal is always grateful for the most help that it can get. If you're asking the general question about advocacy, how to be good advocate, that's a good question. I think of advocacy as being a triangle requiring 3 things, each of which you have to repeat 3 times. You know, when you ask Tony Blair what the most important thing in politics was, he said education, education, education. Right? That emphasizes it. If you asked one of the great property men in London what the most important thing about being a property developer, he said location, location, location. Well, my triangle is a triple, right? So each of them requires 3-fold repetition. And the question is where you begin around this equilateral triangle. I think I would start with analysis. Analysis. Because unless you analyze a problem the right way, you'll never be a successful advocate. But analysis means going into a lot of detail and so on and so forth. And the next thing you have to do is simplify. And then that's all very good, but then you've got to communicate. So I would say that's my triangle: analysis, simplification, communication. How you communicate? Well, you can start breaking that down. But as I tell people, communication, it's done in the first place through analysis and simplification, of course. That's your substantive product. But as for style, what the advocate has to remember is that every every part of her or him is vital. Your voice is vital. How is it pitched? Quiet or loud? When quiet, when loud? Emphasis, I think, is very important. There are advocates, many advocates. I didn't say arbitration advocates, but many advocates I've come across who speak in a sort of monotone. And you can't get hold of anything. It just flows past you. It's very difficult, very, very, very difficult. Listening is much harder than speaking, as the arbitrator will know. And if you speak in a sort of monotone without emphasis, you can't get your point across. Because there are distinctions to be made, aren't there, in the law? And in order to get those distinctions across, you've got to know where to put the emphasis. So how you use your voice is very important. What you do with your eyes is very important. And you look the arbitrator right in the eye. There are 3 arbitrators that help. To look the judge right in the eye is quite difficult. But you've got to face the tribunal. You know, you can't look at your notes all the time. You can't look at the wall. You've got to face the tribunal. What do you do with your mouth? What do you do with your body? Not such a problem for the arbitrating advocate, because the arbitrating advocate is sitting down. So their hands may not be so prominent, their body is not prominent, so on and so forth. But still, you've got to think about that. You've got to think about it all. I did an American arbitration where, although the counsel were told that they shouldn't stand, they insisted on standing. I don't know whether that's standard in America, but in my arbitration in California, the advocates insisted on standing.
They have roving mics as well. They just sort of
No, they stood at a lectern. They stood at a lectern, and they spoke from a lectern. It looked very good. Looked very good. But on the whole, advocates are seated, aren't they? And then, of course, the question is how you do your cross-examination. Aggressive cross-examination, of which I was always guilty. So it's a case of don't do as I do, do as I say. Aggressive cross-examination always looks unhappy. Much better to do it quietly and incisively, and then the witness won't even know what's happening to them. The only successful arbitration I ever conducted as counsel was against a woman ship owner, Greek woman ship owner, who, on the unfortunate death of her husband, had inherited her husband's fleet. And unfortunately, all the ships in this fleet kept on going to the bottom of the ocean with very serious loss of life on top of everything else. And I had to cross-examine her after the loss of the latest ship that she lost. And I was very conscious, because you don't, on the whole, you don't cross-examine women in the commercial court. You cross-examine men. I was very conscious of the fact that I would have to conduct my cross-examination in a less aggressive way, the way in which I used to conduct my cross-examinations. So I was very different, you know, and I asked her very mild questions, but it was all the more successful for that. She did not realize the difficulties that she was getting herself into. So I think aggression doesn't go well. There are some thoughts about advocacy.
Bernard, thank you. You've given us a number of things to think about. Make sure you're in chambers in August.
Yes.
I suppose you say, in the Hong Kong equivalent, I guess, would be Chinese New Year, and all the tips on advocacy. I hope people will forgive me because we're slightly running over time, but I just wanted to ask if there was anything else, that any other tips you would give in more general to how to forge a successful career in international arbitration, remembering that HK45, the sort of principle behind it, is to really help younger
as an advocate or as an
practitioners.
arbitrator?
I think the general principle, I think most people in HK45 would be solicitors or barristers rather than looking for careers in arbitration as arbitrators straight off the bat. So thinking about that.
Well, first thing I would say is something that I don't need to say, and that is work hard. But you all work hard. I think the second thing I would say as an advocate is try to be creative. I mean, you can't be creative about the facts, of course. Facts are very, very difficult. Very difficult. And how they fit together and so on and so forth. That's all very difficult. You have to work hard at that. But where the law is concerned, be creative. And I think that does need to be said, because in the common law world, you are very much concerned with precedents. And so you're always, as it were, looking into the past at the decided cases. And you have to bring your case within the decided cases and so on and so forth. But don't be afraid of thinking creatively. I think that brings its rewards. So hard work and creative thinking, I think that will pay dividends. And because one's speaking to a younger audience, please the people who are senior to you. And that's obvious, isn't it? And whether you have to do that by hard work, by being the early bird, which catches the worm, while your senior person sleeps in bed for another hour, and there you are, you're presenting your senior with finished work that she or he needs that morning.
At midnight before they prepare their presentations, like Robert Goff.
Yes. So he worked when I went home at midnight, but perhaps you should be working at midnight so that you can then hand something to your senior at 5 o'clock in the morning when he or she gets up. However it works.
Lots to think about there. Well, look, Sir Bernard, thank you so much for joining us today. It's a real privilege to talk to you. I really enjoyed the research into your fascinating career and hearing you talk about some of the important issues today. And thank you everyone who's attended today. And if we can thank Sir Bernard in the customary way.
Thank you very much, Ben, and thank you very much. I think the law is a wonderful profession. You don't need to be told that. I hope you don't need to be told that. And I wish you well in it.
And please stay for drinks and the next fireside chat. Keep an eye out for that because the HK45 will be announcing it.